Hello and welcome to the South Carolina Business Review. This is Mike Switzer. Because it is so much cheaper than suing and fighting in court, alternative dispute resolution is gaining favor among plaintiffs and defendants alike, and law firms are noticing this trend and adapting their practices to take advantage of it. Ray Moore is an attorney with the Murphy and Grantland law firm in Columbia, and today he's in our studio. Ray, welcome.
Thanks, Mike. It's great to be with you.
Alternative dispute resolution, commonly referred to, I guess, now in your industry as ADR. Is that a trend that is relatively new?
It's not brand new. In fact, it started to come into prevalence when I graduated from law school just over 20 years ago, as parties began to show the ability to reconcile their differences outside of court. The court system has begun to foster that, and in South Carolina, we started a pilot program that began to encourage litigants to resolve their disputes either through mediation or through arbitration. And over the years, it's become required, and now I think as of January of 2016, it's required in all 46 counties in South Carolina.
Walk us through exactly what this involves.
Sure. Assuming a case has already been filed, and you don't have to wait for a case to be filed, the parties are required within 300 days, unless there's another time set by the court, to mediate or arbitrate a dispute. Now, most cases that go through the system are actually mediated, and what that means is that when the parties are ready within this 300-day time frame, they come together with a neutral mediator, usually is but not required to be certified by the South Carolina Supreme Court, and that person will help facilitate, hopefully, an agreement between the parties. And if they can reach the agreement, then there's no need to proceed with the lawsuit, no need for a trial, whether it be a jury or judge trial, and the parties have control over the settlement with the facilitation of the neutral mediator.
And since this was implemented statewide as a requirement just last year, has this achieved its intended goal? I'm assuming the goal was to alleviate the burden of the court docket?
Sure, absolutely. So it's actually been phased in over several years in some of our more populous and some of our more backlogged counties, and it worked. It did alleviate the backlog. It resulted in settlements very often, and it has worked famously in those counties so much that it has been extended over the years until now, when it is required in all 46 counties.
Are most law firms now including this as part of their practice? Are they bringing on board mediation specialists like yourself, or are they simply partnering with firms like yours who specialize in this?
Sure. Different firms handle it different ways. What you have in some firms like mine, you have a few people who think that they can help others resolve their disputes, and so we've sought out and become certified mediators. In other practices, you have lawyers just step aside from a practice and decide, hey, I think I can do this better on my own, and so they've left ongoing practices to hold themselves out simply as mediators or arbitrators. I practice law. More often than not, I'm litigating, I'm advocating on behalf of a client, but from time to time, I think it benefits me, benefits my firm, and benefits litigants for me to say, hey, I'm willing to be your mediator, I'm willing to be your arbitrator.
What exactly is a certified mediator?
Okay. Well, a certified mediator has gone through the requisite training program that is sponsored by the South Carolina Bar and required by our Supreme Court. It requires us to have gone through a 40-hour, approximately week-long course, and to be familiar with the rules, to be familiar with those techniques that can help other parties facilitate a settlement, to really learn how to be a good listener and learn how to use the skills as a listener to channel that into helping other parties achieve a settlement.
Now, oftentimes when someone is suing someone else, there are punitive damages involved or expected. If a resolution is achieved through mediation, do those disappear?
Typically, a resolution at a mediation will resolve the entire case. It would be very rare that a party who's exposed to punitive damages would want to settle some portion of the case, and leave themselves exposed to punitive damages.
Well, Ray, thank you so much for stopping by our studio today.
It's a pleasure to be with you, Mike. Thank you so much.
Ray Moore is an attorney with the Murphy and Grantland law firm in Columbia. We will have a link to his firm posted at our webpage so you can learn more. Our address is southcarolinapublicradio.org, where you can hear this show again and subscribe to our podcast. With the South Carolina Business Review, this is Mike Switzer.
The views expressed on the South Carolina Business Review do not necessarily reflect those of South Carolina Public Radio.